Right, well, let's get started. So welcome, you are at the GRadulting Workshop series, and today the topic is wills and estate planning. So some of you may have children, some of you are thinking about having children soon, some of you just want to get your act together. It doesn't matter why you're here, I'm glad you're here. So my name is Incapacity, and I'm the coordinator of programs and services for graduate student legal aid. This is just one of the services of legal aid. We do all kinds of things. I am a notary public, so if you need a document notarized, you're going to reach out to our office. That is the one service that we will provide in person. Everything else is done by phone, Zoom, or email. So what other services do we have? We have an attorney on our staff. His job is to help students with local issues. Let's say you've got a horrible landlord and he's not fixing your heat, right? It happens. And he is being unresponsive. What do? You reach out to our office and we will give you some guidance on how to handle that situation. So tenant landlord problems are the #1 reason students reach out to us, but the attorney helps with all kinds of things. So even if you're not sure if we can help you, reach out anyway. Because if we can't, we will refer you to someone who can. Okay? So for our international students, we contract with an immigration attorney. And her job, same thing, consult with students, one-on-one consultation. And we get it. Being an international student is pretty complicated these days. So it is a very popular service. And I encourage you to reach out and request an appointment sooner than later. Because some students wait until graduation time and we may have limited availability. So that's it. There is one more service and I have someone I want to introduce. So this isn't going to happen to any of you, but sometimes students get charged by the Office of Student Conduct for a violation of the Code of Academic Integrity or the Code of Conduct, or they end up involved in a case that involves sexual misconduct. So those students, regardless of what side they're on, we help them navigate the process, right? Very nerve-wracking time, very upsetting time. So we have some advocates on our staff, and their job is to help their fellow grad students go through that process. And today I have Jasmine Kaneda. Wait, Jasmine. Jasmine is one of the advocates on our staff. So if you know someone who's been charged, encourage them to reach out to our office. Okay. So tomorrow I am going to send out a copy of these slides, a link to the recording, and some other information. So watch your email for that. Let's see. Please silence your phones and clean up after yourself. There's trash cans up here. There's trash cans in the corner. So let's move on to our speakers. So today's speakers are returning because we keep having them back because they're fantastic. I feel like I hit the jackpot every time they walk in the room. So I'm happy to welcome 2 speakers. They are both attorneys, Jeremy Rachlin and Liz Farley. Please join me in welcoming them. Thank you. Attorney Rachlin is a partner with, I think I'm going to get this right, Bulman, Dunie,
Yep.
Burke Feld.
You got it.
Woo!
You got it.
Liz is an associate at that place, and attorney Jeremy is in charge of the firm's estate and trust practice group. So he knows what he's talking about, and he has many years of experience, and I would be remiss if I didn't tell you he is also a UMD alum. Go Terps. Woo! So thank you so much for being here. I'm gonna just let them take over.
Yeah. And Liz is also about to be an honorary alum because her husband is starting grad school here in June.
Yeah.
June, yeah, so
There you go.
we'll count you in. Well, Good afternoon, everybody. It's really good to be here. I always say it's like coming home. I graduated here a while ago. And every time I come on campus, pass out like I'm like, oh, there. And I went on to law school up at the University of Maryland School of Law in Baltimore, getting in-state tuition. It is really our pleasure to be here today. Just talk about basics of an estate plan. What are the core documents that everybody needs? What do they do? How do they work? And just kind of demystifying these things because it's really hard to talk about. We give you guys credit for being here on an amazingly beautiful spring day to talk about like death and incapacity and question or decision making, but I'm glad you're here. Our copies of our slides are in the back if you want to take notes, but also we give this presentation here, we've given it here, we've given it a few other places. Really, we love for this to be kind of a free-flowing exchange, and we mean that. So if you have questions, please feel free to raise your hand, ask them during the course of the presentation. Oftentimes with these sorts of presentations, things come up that you don't necessarily want to raise your hand and ask a question in front of everybody. Totally cool. We'll stick around afterwards and be happy to answer some one-on-one questions. Caveat of everything was lawyers through caveats. We are both licensed in Maryland and DC. When it comes to the law, everything is very state specific. Even DC law is somewhat significantly different than Maryland law. We're going to be talking today kind of though globally about global concepts that are pretty much common across all of the 50 states and territories and just kind of general legal principles. So, all right. So, we start with the principle that estate planning isn't just making a will or a trust. Oftentimes, when we consult with folks, that's what they're hyper focused on. It's like, all right, I need to figure out who's going to inherit my assets when I pass away. And yeah, that's part of what we did. But that's only part of it. There's an equally important part that's probably even more important to a lot of you in the room today. In estate planning, yes, we do post-death planning. Who will inherit, who's going to be in charge, and that's part of every estate plan. But equally important, if not more important, is the first part, planning for incapacity. What happens if we get sick? What happens if we're in the hospital? What happens if we can't speak for ourselves and can't act for ourselves temporarily or permanently? That is all accomplished through an estate plan, and that's all accomplished through estate planning. And so we're going to kind of divide and conquer today. I'm going to tackle the first concept, planning for incapacity, and I'm going to kick it over to Liz, and Liz is going to talk about post-death planning, and also subsumed within post-death planning is guardianship, which for most parents, Liz and me included, is oftentimes the thing that we're most concerned about once we have children. So, all right, there are two core component documents of every estate plan when we talk about planning for incapacity, and they work together. They're essentially counterpart documents. So the first document is a document that's called an advance directive, or an advanced medical directive, or a healthcare power of attorney. But the most important part of an advance directive is it comprises two parts. First, a healthcare power of attorney, and second, a living will. So the healthcare, and there are two parts within the same document. The healthcare power of attorney appoints somebody that is called a healthcare surrogate. That is the person who, if the doctor needs somebody to sign something and you are not able to consent to treatment, that is the person who can sign on your behalf, who can make decisions for you, who can basically any medical decision that you could make, your healthcare surrogate can make. So that's the first part, the healthcare power of attorney. The living will is the second part, and the living will, we often joke, is about the most depressing document that we deal with in estate planning. You have to have Dallas and what we do. But the living will, those are end of life. That's guidance to your healthcare surrogate, because if you have a healthcare power of attorney and no living will, you have somebody who you've nominated to make those decisions for you. But the living will is really important because it's your opportunity to express your preferences. What are your goals? What are your values at the end of your life? So those two documents together, healthcare power of attorney and living will, those are the two parts of an advanced medical directive. Talked about it a little bit ago. What sorts of decisions might a healthcare surrogate make? And the answer is really anything and everything. Anything that you could make, any decision that you could make when it comes to your medical treatment, placement, type of treatment, prescription of medication, types of rehabilitation, all of those decisions, any and all of those decisions, those are the decisions that your healthcare surrogate can make for you. So hearing that, okay, that sounds like a lot of power that the person has. Who should I appoint? And really, we don't, obviously we recommend that it just be somebody who is calm under pressure, right? I mean, when we meet with folks to talk about these documents, we're meeting them with them in our office or over Zoom, and we're kind of having a past conversation. We're talking about them in a theoretical way. When these documents are actually used, these are break glass in case of emergency documents. It's not a good day. Things are kind of going sideways. And so we want somebody who is going to be cool, calm under pressure, able to make good decisions, and really kind of aligned with your feelings and understands your values. We get asked a lot, does it need to be somebody local? It doesn't necessarily need to be somebody local. One thing that we do recommend, though, because we do have a lot of international clients living in the DC area, is command of the English language is something that you might want to consider, because this is somebody who might receive a call from a hospital and suddenly be thrust into making decisions and having to process information, a lot of information and a lot of jargon. So something to consider is also that side of it. Can I have co-healthcare surrogates? Should I have co-healthcare surrogates? A lot of times people want more than one co-healthcare surrogate. Sometimes I want both my mom and dad, or the flip side of it is I want both of my kids. And the answer is, yeah, you absolutely can have co-healthcare surrogates. But the bigger question that we reflect back is, should you have co-healthcare surrogates? Because just because you can doesn't mean you should. Anytime you have more than one person that has the authority to act, you are creating, of course, the possibility of conflict amongst them. And so we do, see situations where, particularly it comes up with parents who have multiple adult children who want to put more than one adult child in place because they don't want to cause any hurt feelings. And you can, but what we tell folks is, listen, again, let's step back and think about when these documents are actually going to be used. Bad day, stressful time, things need to happen fast. Can the people who you're appointing unquestionably in a time of stress communicate, collaborate, play well in the sandbox? If the answer is yes, fine, appoint co-healthcare surrogates. If it's anything other than an unqualified yes, maybe take a chain of command approach and appoint one, and then appoint another as a backup. Because you can, with this document, in fact, you should have an initial healthcare surrogate and then a backup name if that initial can't be reached. Who should I give a copy to? Great question. Our recommendation when we're asked this is primary care physician should have a copy of this once you complete it. You don't necessarily have to give a copy to your healthcare surrogate. You just don't. Oftentimes it's a good idea to let them know that you have one in their name, but you don't have to give them a copy. But it is a good idea to give a copy to your primary care physician. And then the last one is, what if I don't have one? So this is, I want to be very clear, this is not like a scared straight presentation, like, you must have this, but we like to talk about, what is the legal consequence if you don't have one? So for medical decision making, most states, Maryland and DC included, have default healthcare surrogacy laws, where if you don't have one of these in place, doctors aren't going to just like scream into the wind. There are people who by default, by law, have priority to serve. But a lot of times that might, especially for folks in their 20s, early 30s, unmarried, oftentimes there might be somebody who is special in your life, whether that's someone you live with, you're in a romantic relationship with, a partner who you're not married to, not a registered domestic partnership, but that's your person. That's the person that you would want to make medical decisions for you. Or if you don't have one, that person is going to have zero legal status in the hospital. Because the people who have legal status and you don't have one by default, usually we start with spouse. From there, we go spouse or registered domestic partner. From there, we go to parents, or spouse and children, adult children. Then we go to parents. Then we go to siblings. So that is just an important thing to know. And I mean, my brother-in-law has been in a long-term relationship with a woman he's lived with for 10 years. They're never going to get married, never going to have kids. But I have said to him, you really should have. He's in healthcare, so he knows. You really need to make sure you have this because that's your person. So, food for thought. So that's the first kind of power of attorney. Second kind of power of attorney, again talking about incapacity planning, is a financial power of attorney. And here I say Maryland, District of Columbia, where we're also licensed, has a statutory financial power of attorney. The financial power of attorney. This is the person who this document appoints somebody called an agent. So the healthcare power of attorney appoints a healthcare surrogate. Financial power of attorney appoints an agent. The agent basically stands in your shoes in anything related to your money, your legal decisions. That's what they can do. So this time of year, you have taxes that need to be filed. This is the person that can sign a tax return for you if you're in the hospital. You need to pay bills while you're and access your bank account. This person can access your bank account for you and make sure that your bills are being paid while you're recovering. So again, the counterpart document, we talked about what sorts of financial transactions might an agent engage in. Really, again, anything and everything relating to your legal rights and obligations and your finances. We always joke if the reason why you're in the hospital is you got rear-ended by an Amazon Prime truck, this is the person that can sue Jeff Bezos on your behalf. But anything and everything related to your financial matters and your legal matters. Again, who should I appoint? Can I have co-agents? Should I have co-agents? So, first and foremost, who should I appoint? Want to be very clear, the agent under a financial power of attorney can be, but doesn't have to be, the same person as a healthcare surrogate. They can be different people. Now, they probably should know each other because if you're in the hospital, one's going to be talking to doctors and one's going to be paying those bills. They probably should have, at least not be told as strangers to each other, but they don't have to be the same person. So sometimes people play the strengths. They have, one person doing medical decisions, one person doing financial. But, when we work with married couples, quite commonly we see them place their spouse, each spouse places the other, and kind of first in line for both. But doesn't have to be the same person. It should be somebody, again, who you unquestionably trust is going to be somebody who has control over your money, can access your bank account. Now, of course, there is civil and criminal liability if they misuse that, but that's an after the fact, good luck catching up. The money might be gone. So somebody who you really trust. Again, you can have co-agents, but we have the same kind of analysis about should I have co-agents. The other thing about who should be appointed, and again, speaking specifically with our international clients, this is something where citizenship or permanent residency may be important given banking regulations. It can be very difficult for a non-citizen, non-permanent resident, non-domiciliary who does not have a U.S. taxpayer identification number to serve as an agent and get access to your bank accounts, because oftentimes the bank is going to require the agent to complete certain forms and documents to have access to the account. So something else to consider is here is also another place where citizenship can matter. What if I don't have one? So this is one where, unlike the healthcare surrogate, the healthcare power of attorney, where there is kind of a safety net, that statutory safety net, if you don't have one, you don't have the same kind of statutory safety net if you don't have a financial power. If you are in the hospital and your name and only your name is on a bank account, and somebody needs to access that bank account to pay your bills, and you don't have a power of attorney, your family or your loved one is going to need to go to court and get an order of guardianship over you. And that is a costly process. It is a time consuming process. It is, I mean, and you know what, it is not easy. And again, not easy at a time of already a lot of stress. So, I mean, in truth, the Maryland statutory financial power of attorney and Maryland form of advanced directive are available online for free. We'll talk about online documents at the very end, but the state of Maryland puts them out there online. Have them. It sounds like you have a notary. This document does need to be notarized. If you have a notary, get these. Get them in place, even if you just go on the Maryland Attorney General's website and use the forms. There's no secret formula to Coca-Cola when we do power of attorneys. We're doing them as part of an overall plan, but we're using the same forms by and large that are out there on the web. So get them. They're important to have. Last thing, and this is not necessarily as pertinent to this group, but a power of attorney ceases to have any validity, any legal effect after we pass away. The power of attorney is only valid during our lifetime. And then once we pass away, if we have an account that's in our name only, then it becomes under the control of the executor of our estate to take over that asset and distribute it. So that is incapacity planning, advanced medical directive, and financial power of attorney. I'm gonna toss it over to you. Give me my microphone. You can take it away.
The even more cheery topic of post-death planning. Oh, yeah, question about.
Yeah.
If you are going back to especially the healthcare one, if you are in the hospital, for example, haven't shared the document, for the healthcare surrogate with anybody, is there a database that, doctors or the people in the hospital keep track of this content?
That's a great question. So and the question, if anybody here is, does Maryland maintain a database? Basically, what happens if you have one and you haven't given a copy of it to anybody? Short answer, to my knowledge, Maryland does not have a database. Some states like Virginia do. Maryland does not. What I can tell you is this is why it's important to share it with your primary care physician, because in an age of just healthcare information being, shared all the time, and I actually know this from personal experience. When you go to the hospital and they are able to find your primary care physician, they are able to get, they're able to get your medical records with your primary care physician very quickly. And so that's why we recommend to give it to your primary care physician, because that's the best way to ensure that if you do go to the hospital, that there is a record of it, even if your healthcare surrogate doesn't race to the scene and can't be reached. Yes.
If you move from Maryland or DC or wherever, do you have to change these documents to do? Great. Yep. And the question was whether if you have to update powers of attorney. And I'm just going to touch on this in a second with wills. Any document that you sign in any of the 50 states is valid upon your move. You don't need to rush to an attorney to update them. In terms of practicality speaking, especially for powers of attorney, since they are state specific documents and certain medical providers or financial institutions, and one state might be more familiar with their own documents, it's always a good idea to just chat with an estate planning attorney once you do move to see if there's anything that's substantively different with your previous documents, and maybe just catch up to date beyond more familiar documents with the people who might be here.
But to be very clear, under federal law, and we won't talk constitutional law here, but it's basically a doctrine that if you execute state governed documents under the laws of a certain state in accordance with the formalities of that state while you're living there, they will be given full faith and credit and recognition in any U.S. state or territory. But again, you're going to talk about this, not necessarily true abroad. We can talk about within the United States, but the same principle does not hold when you leave the borders of the United States. Yeah. So we'll talk about that. So but just in a nutshell, so the financial power of attorney is fine. The financial power of attorney has the ability to access and transact on your bank accounts while you're alive. And then of course, if you need help, and then upon your death, the account effectively locks and can only be unlocked and reached by the person who is appointed by a court as the executor of your estate. We call that the personal representative of your estate. So it's a bit of a process, but oftentimes people will, it has come, we've gotten calls from people that say, I tried to use my mom's power of attorney and they won't let me use it. Well, okay, tell us a little bit more. Well, mom passed away 2 months ago. Well, that's your problem. The power of attorney is no longer valid. You need to open up an estate and have somebody appointed as the personal representative of the estate, which we'll talk about now.
Yep, just speaking to it by a few seconds. But I'm gonna kind of review that post-death planning, so this kind of traditionally comes into play through a will or a trust for more advanced planning. And so I'm gonna just kind of briefly go over what you need in your will to make sure that it's valid under this in Maryland, but also generally these principles kind of apply across the board anyways. So first and foremost in Maryland, for a will to be validly executed, the only thing that you need is for it to be signed by 2 adult witnesses. You don't actually need it to be notarized in Maryland, not a bad idea, but really just need to have those 2 adult witnesses witness you actually signing the document. There's a ton of case law and horror stories about the witnesses not actually seeing the person executed, so it's important that they actually see the pen touch the name. What actually transfers via a will? And this is a little bit less than what most people think would transfer under a will, because anything that you own jointly with another person, so commonly spouses own their home and jointly together, would not pass under a will. Any joint asset passes automatically to the joint owner. Same thing with anything that has a beneficiary designation. So when you fill out a form to complete a retirement form, you have to name a designated beneficiary who would receive the account upon your death. Any asset with that beneficiary designation, commonly called a pay on death or transfer on death designation, all of that passes outside of the purview of your will. So that's why I say that it ends up being a little bit more limited than what does actually pass under a will.
And same principle for any asset that has a beneficiary designation. So life insurance policies, when we take out a policy of life insurance and we complete a designated beneficiary, we say my spouse or my child or my parent, as long as there's a designated pay on death beneficiary, it is a relatively quick process after we die, and the beneficiary presents a death certificate, money flows. It's not part of your will.
And then it's also important to note that anything on top of it happening outside of your will, that you need to make sure that these are updated with what you want your wishes to be. I know when I was younger, I had my my parents on everything that they would hear everything. On getting married, I think my husband would have been pretty upset if my parents got everything instead of him. So make sure to update those beneficiary designations, because anything that's in the designation would trump what's in your will. So all of those designations kind of act as a mini will for that asset. What are the essential elements of a will? So what should you make sure that's included in a will? The first thing that you're going to want to make sure is included is who's going to inherit your stuff. So who gets your clothes, your jewelry, car, all of the stuff that if you were to pick your house up and shake it, everything that falls out. That's one thing that you're going to want to identify in your will as to who you want to inherit. Same thing for monetary assets. So this would include bank accounts that aren't jointly owned. So bank account in your sole name, any sort of investment account that doesn't have a beneficiary designation, any sort of account that has a dollar sign in front of it that doesn't have a beneficiary designation and isn't jointly owned, you're going to want to make sure to have that covered under your will. This guardianship provision in your will is probably what most young families come into our office looking for. This is kind of what has inspired them to come and do estate planning. And the guardianship provision is who would have custody and care of your child or children in the event you and their other parent were deemed unable to parent. So similar to what Jeremy had touched on with the guardianship provision for the powers of attorney, you would still need to have a court process just to determine who would actually be the guardian of your child. but naming a guardian in your will gives great preference to the person that you identify as who you want to have custody of your child. That is a very important provision because otherwise, similar to the kind of statutory scheme, or the statutory scheme in terms of who would, the court would give preference to serving, then that might be someone very different than who you want to have control of your child if you're not able to parent. And it also can help prevent fighting between both sides of the families as that who gets custody of the children. And then last but not least is the personal representative or the executor, commonly known as, and this is the person who is tasked with winding up your affairs. So they kind of take on a similar role to the agent that we were talking about under the financial power of attorney, but this role only kicks into place after you've passed away. And this is the person who is filing your final tax returns. They are the ones that get to work with the probate court or hire an attorney to help them do so. They get to round up all of your assets and make sure that it gets distributed to whoever you want it distributed to under your will. They're kind of the captain of the cruise ship in terms of who gets what and keeping on top of court deadlines.
That's a new one. I've never heard probate described as a cruise ship, but I will never take a cruise.
Well, hopefully.
Hopefully my cruise in June does not turn into, oh my god.
And we already kind of touched on this, that your will remains valid if you do move states. Again, there are certain nuances with every state when it comes to wills. Like for example, in BC, you want to specifically waive that they can serve unsupervised if that is something you're interested in, so that the court can kind of keep their hands out of the personal representative's way. Maryland doesn't have that same requirement. So it's important to speak to a different attorney depending on which state you're in. But if you don't get a chance to talk to an attorney after you've moved and you've already signed a will, it's not that your document goes poof and doesn't work. It still works. There might just be some specific content that you over included or under included. And last but not least, for foreign property distribution, you have international students. Every state is different, so that even applies more so for every country when it comes to inheritances. And I'll touch on this a little bit more, but every country has very different inheritance schemes and very different rules when it comes to inheritance. So if you have foreign property, what we typically recommend is consulting with an attorney in the country that you have that foreign property in, and they can advise you just because everything is so different when you cross borders.
I would just a quick example, I mean, especially when it comes to real estate. That is one thing where different countries have laws of forced heirship. Basically, it doesn't matter what your will says, there's a forced priority by the law of that country of who inherits. And if your will is in conflict with that, it can create a huge mess, or it won't even be recognized. Same holds with the bank account. So international property does, I mean, in truth, it does kind of need at the eyes of an estate attorney who's familiar with the inheritance laws of that specific country or jurisdiction.
What about across state lines? Would you, if you have property that, you know, spans outside of Maryland, for example, is there anything that you need to consider about that within the US?
Yes, so if you own property, I mean, you get this a lot in Maryland, we have a lot of people who own property here or in Delaware, here and in Florida. Every state that you own real estate in, you need to go through probate in that state. So that's one reason why some clients opt for a trust, because that can help bypass that process. But in terms of real estate, that's kind of just how the cookie crumbles. With other assets, they typically can pass the beneficiary designation or would apply under the terms of your will. But real estate is treated a little bit differently just because it's actually in existence in that other state.
But your will, to be very clear though, your will can still include, so if you have a Maryland will, your Maryland will can include the disposition of your Florida real estate. But it's going to be a secondary post-death proceeding in the state of Florida to actually have somebody appointed who can sell that property. But you don't need a separate Maryland will and Florida will for your Maryland property and your Florida property. It's more of kind of like how it's handled after you're gone. That there's a distinguish, that there's the difference.
You mentioned something about a trust. What is that?
So a trust, I always describe it as a bucket that you can put assets into during your lifetime. The main pro of a trust is that any asset that makes its way into the bucket during your lifetime gets to avoid the administrative process called probate. That's the process that you have to go through, and I'll actually skip to the next slide because that was what I was about to cover, so thank you for the great segue. But the probate process is basically how an asset changes hands from one person to the next person that you want it to. A trust can help just bypass that process. That's the main difference. We see trusts a lot when people own property in multiple different states, so they don't want to have to go through 2 administrative headaches. One's enough, but a trust can help just ease that administration.
And there is another kind of trust, and we're happy to talk to you afterwards. There's a different kind of trust that you can put into your will that's more oriented towards protecting a child's inheritance or deferring if you have a child and you want them to inherit or have an inheritance held for their benefit until a later age. You can actually put that kind of trust that's called a testamentary trust, and that's a different kind of trust, and you can house it within your will. Has nothing to do with the type of property that you own and everything to do with, all right, I don't necessarily want a 21-year-old to get like $1 million of life insurance because they make a lot of bad decisions on Route 1 if they got $1 million. So I want it to be held for their benefit and until they're at a more mature age. So that's a different kind of trust. We're happy to chat briefly afterwards.
One thing that state planning attorneys love to say is that everyone has a will, and it's either the will that you drafted or the will that the state has drafted for you. And what I mean by that is that similar to what we've already talked about, these statutory schemes with the financial powers of attorney and the appointment of a guardian, the same thing applies for wills or for inheritance. These are called the laws of intestacy. And essentially that just means that if you don't have a will, the state of Maryland simply says that if you have a spouse or a registered domestic partner, they inherit, then children, then it goes to grandchildren, and then kind of back up to parents and down the family tree and so forth. So what we mean by when we say is that everyone has a will is that it's whether you drafted it, how you want it to look, or whether you're going to be defaulting to what the state of Maryland or whatever state you live in has already picked out for you. So I already kind of touched on it, but it typically goes down the family tree approach. And again, these assets that would go down that family tree approach through the laws of intestacy would just be any of those assets that aren't jointly owned and don't have beneficiary designations. So many times it can be your home, if it's not jointly owned, would have to go through pass via the laws of intestacy. Same thing with the stuff in your home or any other bank account that doesn't have the joint owner on it. Who would serve as your executor in the event that you don't have a will? So in your will, you will hopefully name an executor who you want to serve. But again, the state of Maryland or BC has a list of people who would serve if you don't have an executor or if you don't have a will. And again, it's that kind of family tree approach, kind of similar schemes to what we've already discussed. Similar for guardian, it gets a little bit trickier just because, especially if they're both parents of the child have passed, both sides get to try to take their bite at the apple and get to see who would inherit or who would have custody of the kid. And then it ultimately comes down to the judge to decide who would be the most fit to have the parent. That's again probably why guardianship provisions, especially if you have minor children, are the most important provision in your will, because again, already going through a rough time, the child doesn't have either of their parents who can parent. So if you have it in your will, it just makes it a lot more simple and streamlined and an already tough process that no one wants to go through. Any questions on any of that? Okay. Debt and taxes. No matter what, the state will always get their taxes paid. Whether that be estate tax or inheritance tax, every state is really different when it comes to what gets taxed after someone passes away. Generally speaking, in the United States, an inheritance is not taxed on the person who's received it. But any sort of income that's received on an account would be taxed as income. So for example, if you were to inherit a investment account because your parents have passed away, just receiving that investment account, you generally don't have to pay any tax on it. But say over the course of the day, that investment account gained $100 just because the market was doing really well, you would have to pay tax on that investment account. But generally speaking, in the United States, inheritances are not taxed by the person who's received them. This is very, very different for any person who's not a US citizen or not a US permanent resident or domiciliary. The rules are very, very different for people who fall into that bucket. And you can see on here, it says that anything over $60,000 might be taxed up to 40%. So that can be a really large chunk of money. So that's when we definitely encourage clients to go and talk to your CPA, talk to an accountant or an attorney to try to iron out what ways there can be to make sure that those assets aren't triggered. Yeah.
Does that amount vary from state to state? Stuff
So, yeah, so just kind of want to also highlight two things. So the last two bullet points on here, the red type and the gray type. So the red type deals with, kind of inheritance by non-US citizens of foreign assets. So if you are a German resident and you live in the United States and you inherit a German asset. Germany, I know this because we've had German clients, Germany taxes the heck out of inherited assets. And so, not it doesn't matter that you live in the US, if you're a German resident, you inherit a German asset, you are going to pay German tax on it. That's the second. So the red talks about kind of the foreign tax that you pay to a foreign government. The gray text talks about tax that is owed to the United States government. So, and what that focuses on is a concept that's called estate tax. Estate tax is a tax that is assessed on the privilege of transferring wealth. It's assessed on the person that dies, on their estate, not on the recipient. Because as we talked about in the blue, the recipient rarely pays tax. It's a very unusual concept. Most people are like, wait, if I inherit $1 million brokerage account, I don't pay tax. Correct. Congratulations. But only correct, estate tax is a tax that is levied on the person who passed away and has to be paid by their estate. Now there's state estate tax and there's federal estate tax. So state estate tax, Maryland is one of 14 states that assesses state estate tax. In Maryland, you can transfer up to $5 million free of state estate tax. Free of state estate tax. And spouses can combine that and basically stack and get 10. Now, for US citizens, when we talk about federal estate tax is a big number because the federal estate tax rate is 40%, which is one of the highest tax rates there is in the tax code. The state estate tax rate, state of Maryland, state tax rate is 16%. Federal estate tax. US citizens, permanent residents, domiciliaries, $15 million free of federal estate tax. It is the one big beautiful whatever that law is called. But it is, we had many clients with cognitive dissonance who hated everything about that law, but said, wait a minute, now I can pass $15 million free of federal estate tax? Hey. Very different though. Very, very, very different for non-citizen, non-permanent resident, non-domiciliaries. That $15 million number drops down to $60,000. Everything over $60,000. It does not include life insurance. So if there's a bank account, an investment account, a house. Now, if you have a house, you're probably going to be a domiciliary. So bank account, investment account. Anything over $60,000, forget $15 million, anything over $60,000 has tax at a rate of 40% that has to be paid. So that's the kicker when it comes to the state tax. So Debbie, I know we just answered your question with a lot, but kind of breaking down what you were talking about was state estate tax. And those states that do assess state estate tax do differ greatly. Maryland assesses state estate tax, $5 million. But we're also very focused on federal estate tax, particularly for non-citizen, non-domiciliaries, because that $60,000 threshold is so unforgiving. And so different from the $15 million.
So is this all based on your state residency? Is that really kind of what drives this?
So all the laws apply to the state that you were domiciled in when you passed away. So
Even if you're a resident of a different state.
so residency and domiciliary are they kind of overlap. What is determined is where you had your driver's license, where you were registered to vote, where you own real estate, and of course, owning real estate in multiple states can make it confusing.
Where you pay tax.
Where you pay
pay tax.
Yeah. Yeah, what we see with a lot of like snowbirds is that they actually hold on to like plane tickets to show that they were in Florida for a certain amount of days each year to determine that they were domiciled there. But we always say you need to change your driver's license, you need to pay Florida income tax, and you need to make sure to register to vote in Florida to make sure that it's established.
All right, so you wanna go first?
Sure.
First. All right, so, all right.
So these are kind of not necessarily legal advice or legal things, but more just kind of common sense things that pop up almost with every single client. And the first one is that the biggest mistake that we see clients make is they don't make a cheat sheet for the people who might be taking control of their assets, either because of capacity or after they passed away. So how do they know where you were banking? How do they know where you held bank accounts? How do they know where your retirement account is? Creating the cheat sheet that just says, here's where I bank, here's my contact at this bank, here's my retirement account, here's where my investments are, here's where my mortgage is paid through. All of these things can just help make that process a little bit more seamless. So we always advise clients that no matter what, if you don't want to move forward with having a will, don't want to move forward with the plan, still make sure to have that cheat sheet ready to go to help out whoever has to might maybe step into place and try to take control of your assets.
Yeah, you don't have to give that document to people. Be very clear, you don't have to like hand that out so to whoever you may and say, hey, here you go. If this is, and again, you know, people leave our office if they do planning and they have all of their estate planning documents in an envelope. And it's kind of like the break, again, with the same now, the break glass in case emergency envelope. And within that envelope, that's where you put the cheat sheet. But again, envision a situation, you're in the hospital, and all the things that are muscle memory to you. I pay rent on this date. This is how much my rent is. This is the term of my lease. Or it's on auto debit. It comes out of this account on this day. Those are the things that if you're in the hospital for a month or 2 months or longer than that, and someone needs to step in, think about it if you had to step in and manage a parent, what the information is that you would need. And it's never gonna be perfect, but the more information you can give, the better. Just make sure you update it from time to time.
The other thing with that,
No.
is including passwords to things on this cheat sheet. Especially now with dual authentication, we have had so many clients who say, I have had my mom's password to her Gmail, but I don't have it, or to her phone, but I didn't have her Gmail password, so I wasn't able to access anything anyways. So that's the other thing that has added even more tricks to this, is making sure that people have passwords, and again, to be on a secure sheet that you don't even have, given them ahead of time, but just that they have access to that information.
Yeah, or even those password apps, like 1Password or something like that. Next one, failing to review your documents over the years. Liz alluded to this a little bit, and frankly, we've already been through it. My wife and I, in terms of kind of an initial set of documents that appointed some, parents, and then at parents' age, like it's, I have a 15-and-a-half-year-old. She can be challenging for parent for us, let alone if she had to go to, her grandparents. That would probably put them into the ground. So we had to, update our documents. If you get married, you want to update your documents to make sure that suddenly, now you or register as partnership. You don't want your parent to be the healthcare surrogate. You want your spouse to be your healthcare surrogate. So, we recommend, it's not like you have to pull this thing out every year, but if you have a major life event that happens, birth of a child, wedding, loss of a loved one. It's a good time to just take a look at the documents and make sure, if you have the documents, to make sure that they fit your current needs.
And I also already kind of touched on this earlier too, but for updating beneficiary designations, again, make sure to update them from. You're young, you might have parent, sibling in there, you're gonna wanna update them to include spouse, partner, children. And then same thing, if you have multiple children, making sure to update them after each child, or simply just putting my children on there, so that way. Kind of anyone that falls under the umbrella of child is equally included. You don't want to just name one child and have your second born and be forgotten as a second born, I would say that.
Next one, and this is becoming more and more prevalent. Listen, I mentioned this earlier. I'm a big believer in if you need basic legal needs and there are state forms that are out there, use them. And there are some things that, in fact, LegalZoom, ChatGPT in the law world, I think they're okay with it. You're starting a business and you just want very basic corporate, I'm sure our business partner would hate this. But you need basic corporate documents, just to register your business. Fine. But Liz and I see clients who come to us to ask us to review their documents with them. And when folks use ChatGPT or LegalZoom, they'll hit the best way to describe it is the core concepts are going to likely be there, but the nuance isn't going to necessarily be there. I mean, the example that I gave, and I talked about this a little bit ago, we had a client whose spouse passed away. They used ChatGPT, I can't remember what she got to do the will. It's a perfectly valid will. Except ChatGPT did not know, or did not pick up from the District of Columbia. You need to be a United States citizen or permanent resident to be eligible to serve as executor of an estate, even if it's your spouse that does. The wife's will names her husband, who's a non-citizen, non-permanent resident. So now suddenly we have a will that's valid, except it's missing an important part. We don't have a valid nomination of an executive. So we kind of have to fix that. So, I mean, I will say this again, I'm a believer. If you do nothing else, you can leave here today, go online, fill out the state advance directive and power of attorney, they're available online. But, LegalZoom, ChatGPT for wills, trusts, bad idea.
And last but not least is, again, we've kind of already touched on this, but just failing to take into consideration that every state, and again, every country's inheritance rules, probate rules, will rules are all super different. So just making sure to touch base with someone who's familiar with the laws of that state or that country. Especially when it comes to what Jeremy was mentioning about the taxes, with the $60,000 versus $15 million, that's a huge difference. So just making sure to be familiar and talk to someone who is familiar with each state or each country that you're going to be dealing with. Yeah.
That's it. Thank you guys again for having us. We I think our contact information is on the slides. We'll also stick around and answer any questions that you might have. I know there's one question I kind of referred about testamentary trust. But thank you so much for having us. And reach out if you have questions. Our goal when we talk to people is it's hard stuff to talk about. It's hard stuff to think about. And the way we look at our job when we work with families come to us is to make this understandable, accessible, and as comfortable as it can be, and then just kind of cross it off the adulting to do this. So that's what we hope this has been for you today to understand a little bit more about it. So thanks for having me.
Thank you for coming back again. Great presentation. Everyone is going to follow up, right? Yeah. Okay. Well, I'm glad you came out today. Please, we've got lots of food, so if you want to take a few more nuggets, there's some falafel for the road. Please help yourself to that. We've got another workshop next week, and it is Grad Student Appreciation Week, so it'll be a little special. So I think you should come to the workshop. It will be in this room, and the topic is negotiating your salary, reviewing a job offer. Yeah. No, because I want you to stay where you are. Anyways, hope to see you next week. Enjoy the beautiful weather and let us know when you need help. Thank you. Yeah.